Hey, thank you everyone for joining us today. My name is Diana Padierna, and I am the Executive Director at Landlord Self-Help Center. We are excited to resume our Landlord Lunch and Learn series, and so I'll start with a few housekeeping reminders before we begin. This webinar is being recorded and will be available on the Landlord Self-Help Center's website if you would like to rewatch it later. The Q&A feature is enabled, and you are welcome to submit questions related to this webinar. These questions will be addressed during the Q&A period at the end of the webinar. Please note that our presenters will be only answering questions related to today's presentation. If you have questions about your own specific situation, please contact our office during our business hours. Okay, so let's get started.
Hello, and welcome to the Landlord Self-Help Center's Landlord Lunch and Learn session. My name is Catherine, and I'm a community legal worker and licensed paralegal. My colleague Ashley is also going to be presenting today. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. Landlord Self-Help Center was founded in 1975 and incorporated in 1977. We have a province-wide mandate to support the small-scale landlord community, and approximately 80% of our resources are dedicated to client services. This Landlord Lunch and Learn session is the second one of this year's series and will be focusing on beginning a tenancy. The presentation will be made available for replay on our website through the YouTube channel platform, along with our past presentations. At the end of this presentation, we'll be having a question and answer period. You can use the Zoom function found at the bottom of your screen to ask your questions. Again, please note that this information in the presentation is intended for general information only and not legal advice. Our land acknowledgement. At the Landlord Self-Help Center, we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the William Treaty signed with multiple Mississaugas and Chippewa bands. As a community legal clinic funded by Legal Aid Ontario with a province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario, and we make this acknowledgement in support of the necessary work of reconciliation. The Residential Tenancies Act was created in 2006 and is the Ontario legislation that governs most residential tenancies and matters related to rent in Ontario. The Residential Tenancies Act is commonly referred to as the RTA. The RTA establishes laws for landlord and tenant obligations, rights, and responsibilities. It regulates rent, such as rent increases, and provides tenants with security of tenancy and outlines grounds for termination of tenancies. There are rental agreements that do not fall under the Residential Tenancies Act. The most common exemption is if the renter shares a kitchen and or bathroom with the owner, the owner's child, the owner's spouse, or the owner's parent. Tenancy agreements. Tenancy agreements in Ontario are recognized regardless if they are verbal, written, or implied. Landlords should be cautious that even if there is not a written lease or contract, simply accepting money in exchange for housing establishes a tenancy agreement. Once a tenancy agreement is established, it does not expire. As such, at the end of the fixed term, the tenancy automatically continues month to month. Additionally, anything that both parties mutually agree to, whether verbally or in writing, that contradicts the Residential Tenancies Act will not be enforceable. Lastly, agreements cannot be unilaterally changed by one party. The Landlord Self-Help Center encourages all landlords to make sure that they have a well-drafted agreement in writing, which brings us to the next portion of the presentation. On Ontario Standard Form of Lease. The Ontario Standard Form of Lease was created in April 2018 and is the Ontario government's version of a lease agreement, sometimes referred to as the Residential Tenancy Agreement. It contains sections to input all relevant information, allows for additional terms to be attached, and includes an appendix that outlines more information about lease terms, tenants' rights, and landlord's obligations. The standard form of lease is only to be used when the RTA applies. For lease agreements signed on or after March 1st, 2021, it is mandatory that the most updated version of the standard form of lease be used. The latest version was created in December 2020. Landlords should be aware that Section 12 of the Residential Tenancies Act states landlords are required to give a copy of the agreement signed by the landlord and the tenant to the tenant within 21 days after the tenant signs it. If a landlord fails to provide their tenant with the standard form of lease, the tenant can ask for a copy in writing. If the landlord fails to give a copy to their tenant within 21 days, then the tenant is legally entitled to withhold 1 month's rent. If the landlord still does not provide their tenant with a copy of the lease within 30 calendar days after the date that the tenant withheld that 1 month's rent, the tenant is legally entitled to keep it. In other words, by not using the standard form of lease or providing it to the tenant, the landlord could lose 1 month's rent. The latest version of the standard form of lease can be found on the first link that you will see on the slides. The Ontario government has also prepared a guide to the standard form of lease in different languages, for example, Spanish, French, Italian, Portuguese, Hindi, and Chinese. The guides can be found at ontario.ca/page/guide Ontario Standard Lease. Lease agreements are legally binding documents and should be prepared cautiously. A portion of this presentation will discuss the different sections of the standard form of lease. However, landlords are encouraged to seek legal advice before preparing their lease agreements. I will now pass it over to my colleague Ashley, who will get started with the different sections of the standard form of lease.
Thanks, Catherine. So I'm going to be talking about parties to the agreement. Only tenants should be listed on the lease agreement. Minor children, guarantors, and occupants should not be listed or included on the lease. Joint tenants. In a joint tenancy, there is one rental agreement to which all of the tenants agree and sign. In this type of tenancy, all the tenants are jointly and severally liable for the payment of the entire rent for the rental unit and for the cost of any damages. This means that if one tenant stops paying their portion of the rent, the other tenants are still responsible for the total rent amount owing and/or for the total amount of the cost of any damages to the rental unit. A notice of termination of a tenancy must name and be given to all of the tenants who sign the lease. One tenant cannot terminate the tenancy agreement on behalf of the other tenants. Tenants in common. Tenants in common have separate tenancy agreements with the landlord and live separately from one another, such as in the case of a rooming house. Each tenant in common is responsible for paying his or her share of the rent for the rental unit. A notice to terminate tenancy would be served to the particular tenant that the landlord is looking to evict, and the rental unit should be clearly identified on the notice. Occupants and roommates. An occupant or roommate is a person who lives and shares the rental unit with the tenant and is not considered a tenant. This can be done with or without the consent of the landlord. The tenants are responsible for their roommates or occupants. Guarantor. A guarantor is a person that guarantees the payment of rent by the tenant. Since the guarantor does not have the right to occupy the rental unit within the meaning of the RTA, they should not be named as tenants in the rental agreement or on a notice to terminate the tenancy. The landlord and guarantor should sign a separate guarantor agreement. We have a guarantor agreement under the Members Lounge section of our website, which is landlordselfhelp.com. Rental unit. The rental unit needs to be clearly identified in the standard form of lease agreement. A landlord should be very specific. If you are renting out only the main floor unit of the house, the address should be specified as main floor unit, 123 Baker Street on Toronto, Ontario, and the postal code. If you are renting out individual rooms, each room should be clearly labeled and numbered. An example would be room number 1, main floor, 123 Baker Street, Toronto, Ontario, and the postal code. If a tenant is renting out the full property, it should be specified whether they have access to the backyard or additional storage options. All included amenities, such as pools, basement access, etc., should be clearly outlined on the lease agreement. It should also outline whether or not the unit is a condominium. As Catherine mentioned earlier, if the renter unit has shared accommodations with the landlord or landlord's immediate family, you should not be using the standard form of lease, and it should be clearly outlined and described in a rental agreement that states that it is a shared accommodation. Contact information. A landlord must provide a tenant with the legal name and address of the landlord. Section 12 of the Residential Tenancies Act states, every written tenancy agreement entered into on or after June 17, 1998, shall set out the legal name and address of the landlord to be used for the purpose of giving notices or other documents under the Act. Section 12, subsection 3 states, if a tenancy agreement entered into on or after June 17, 1998 is not in writing, the landlord shall, within 21 days after the tenancy begins, give to the tenant written notice of the legal name and address of the landlord to be used for giving notices and other documents under this Act. Failure to comply, until a landlord has complied, the tenant's obligation to pay rent is suspended, and the landlord shall not require the tenant to pay rent. After compliance, after the landlord has complied, the landlord may require the tenant to pay any rent withheld by the tenant.
Sorry, I'm just having an issue with my screen sharing.
Term of tenancy. Termination only in accordance with the Act. Section 37(1) of the Residential Tenancies Act states, a tenancy may be terminated only in accordance with this Act. This means that a fixed-term tenancy automatically goes month to month once the fixed term has been completed. This means there's a potential for a long-term relationship between landlord and tenant. Valid reasons to terminate a tenancy include non-payment of rent, damages, interference with enjoyment, own use at the end of a fixed term, persistently late rent at the end of a fixed term, demolition, repair, or conversion at the end of a fixed term.
Setting the lawful rent. In our last Lunch and Learn, we discussed in more detail the rules around setting the rent price. When entering into a lease agreement, landlords are allowed to set the rent price to the amount they wish or the amount the market can bear. This is referred to as vacancy decontrol. However, once the rent price is set, most rental units are subjected to rent control laws, which means landlords can only increase the rent every 12 months by the increased guideline amount set out for that year. For 2025, the increased guideline amount is 2.5%. For more information about guideline increases, you can visit ontario.ca/page/residential rent increases. Continuing on with rent. The lease agreement will establish the date the rent is due and how frequently the rent payments are due. Standard practice is to charge rent monthly on the first of every month. The lease agreement will also outline what is the base rent and any additional service charges, such as parking, utilities, or storage, which establish what is called the total lawful rent. Charges that are in addition to base rent must be the same amount on a monthly basis and are subject to the rent increase guidelines. For example, if the lease establishes base rent is $2,000 per month and parking is $50 per month, the total lawful rent is $2,050. The landlord can calculate the annual increase using the full amount of $2,050, but the landlord cannot increase the charge of parking specifically. The lease agreement will also outline who the rent is to be paid and how the rent is to be paid. Check or e-transfer are the most common methods landlords accept, landlords accept rent payments. If a landlord accepts check as a means of rent payment and the check is returned due to non-sufficient funds, the landlord can charge an administrative fee up to $20 plus any NSF charges made by the landlord's financial institution. NSF charges clause is very clearly outlined in the standard form of lease that you see here on the screen. The standard form of lease also outlines any partial rental periods. If a landlord is allowing their tenants to move in before the first of the month, they are entitled to charge them a daily rental rate. Daily rental rates are calculated by multiplying the total lawful rent by 12 and dividing it by 365. As you can see on the screen, the partial rental period should be very clearly outlined as to what dates it applies and how much the rent is going to be charged. Some rules around rent. Landlords should be cautious that Section 108 of the RTA states that neither a landlord nor a tenancy agreement shall require a tenant or prospective tenant to provide post-dated checks or other negotiable instruments for payment of rent, or permit automatic debiting of the prospective tenant's account at a financial institution, automatically charging a credit card, or any other form of automatic payment for the payment of rent. The key word about this section is that it states require. If a tenant wishes on their own to provide a landlord with post-dated checks or to set up automatic payments, the landlord can accept them. However, it is advisable to keep records showing that it was the tenant who wished to provide these forms of payment. Section 109, subsection 1 of the RTA states, a landlord shall provide free of charge to a tenant, former tenant, on request, a receipt of payment of any rent, rent deposit, arrears of rent, or any other payment to the landlord. Because of this, landlords should keep records of how and when payments were received. Moving on to service and utilities. The lease agreement will also outline what is included in the rent or who is responsible for all services and utilities. The standard form of lease outlines the most common service, such as gas, air conditioning, additional storage, on-site laundry, and guest parking. You can see on the screen, landlords are allowed to charge on a per-use basis for coin laundry and guest parking. Landlords must understand that anything they include as a service or utility in the lease agreement will be their obligation for the remainder of the tenancy. The landlord cannot unilaterally impose a change to the agreement of what utilities or services are included after the commencement of the lease. For example, a landlord cannot begin a tenancy where utilities are included and attempt to charge for utilities later on during the tenancy unless the tenant agrees and the rent is reduced. In this case, it would not matter if the tenant's usage of utilities significantly increased. If a landlord is making their tenant be responsible for utilities, it should be very clearly outlined in the box provided in the standard form of lease. This is the most advisable practice, as the tenant would be responsible to pay for their usage every month. AC laws. The Helping Homebuyers Protecting Tenants Act of 2023 will create amendments once it's proclaimed to the RTA to introduce section 36.1, which states a tenant may install and use a window or portable air conditioning in a rental unit for which the landlord does not supply air conditioning unless prohibited by doing so by the landlord under subsection 2 and subject to the conditions of subsection 3. Those conditions include: before installing the air conditioning, the tenant must notify the landlord in writing. The tenant shall ensure that the air conditioner, including its installation and operation, does not damage the rental unit or residential complex. And the air conditioner must be installed safely and securely. If landlords are including AC as one of their services, they should be mindful to their municipal bylaws. For example, in the City of Toronto, a landlord who provides AC is required to ensure it's operational from June 1st to September 30th, and that it can maintain an indoor temperature of no more than 26 degrees Celsius. Moving on to rent discounts. The Residential Tenancies Act allows for discounts as stated in section 111, subsection 2. The standard form of lease also includes a section where landlords can outline the discounts. Common discounts include a 2% prompt payment discount or the first month's rent free as a move-in incentive. At the Landlord Self-Help Center, we do not advocate for discounts. If applied incorrectly or carried on too long, the landlord runs the risk of the discounted rate becoming the new lawful rent. Rent deposits. The Residential Tenancies Act under section 105, subsection 1, states the only security deposit that a landlord may collect in a rent deposit collected in accordance with section 106. 106 states a landlord may require a tenant to pay a rent deposit with respect to a tenancy if the landlord does so on or before entering into the tenancy agreement. This means if you do not collect a deposit before entering into the tenancy agreement, you cannot force your tenant to pay a deposit afterwards. Subsection 2 states the amount of a rent deposit shall not be more than the lesser of the amount of rent for 1 month period and the amount of rent for 1 month. Security deposits, damage deposits, and pet deposits are considered unlawful. Deposits cannot be applied to anything other than the last month's rent and cannot be withheld for damages. Moving on to the interest on last month's rent. Additionally, the deposit or last month's rent is subject to interest as per section 106, subsection 1 of the Residential Tenancies Act, which says a landlord of a rental unit shall pay interest to the tenant annually on the amount of rent deposit at a rate equal to the guideline determined under Section 120 that is in effect at the time payment becomes due. For example, the guideline amount for 2025 is 2.5%. Interest would be owed to the tenant for the last month's rent on the anniversary of when they collected it for this year at the amount of 2.5. If the rent increases during the tenancy, the landlord can ask for a rent top-up or apply the interest as the top-up. More information can be found about this practice in Section H of the Standard Form of Lease Appendix.
Key deposits. Key deposits must be refundable upon return of the keys at the end of a tenancy. A landlord is not able to keep the key deposit to cover any other expenses such as unpaid rent, utility, or damages. A key deposit cannot be more than the actual replacement cost of the keys. For example, it would cost $30 to get a new replacement set of keys made. Your key deposit must be no greater than $30. Smoking. Under provincial law, smoking is not allowed in any indoor common areas of a building. A landlord should add any additional smoking rules to the standard form of lease. If you do not want smoking in the rental unit or within so many meters from the rental complex, this should be clearly outlined in Section 10 of the standard form of lease. If you want to prevent the smoking of cannabis in the rental unit, this should also be clearly identified and listed under the smoking rules. When drafting smoking rules, you must keep the Ontario Human Rights Code in mind. We will discuss the Ontario Human Rights Code in more depth later on in this presentation. However, it is important to keep them in mind when drafting smoking rules, as a landlord cannot discriminate based on disability, as well as race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status. Smoking, including cannabis, can sometimes be considered a medical necessity in specific circumstances or may have specific ties to cultural or religious practices. Insurance. If you wish to require the tenant to maintain liability insurance, Section 11 of the Standard Form of Lease should be selected. If this is selected, the tenant will have to maintain liability insurance and provide the landlord with proof of same when requested. The Landlord Self-Help Center highly encourages landlords to select this to ensure that tenants maintain liability insurance for the duration of the tenancy. A tenant can also opt in for additional contents insurance if they would like.
Additional lease clauses. Both the Residential Tenancies Act and the Standard Form of Lease allow for landlords to create additional lease clauses or rules. These additional clauses should be written in clear language and as a separate document signed by all parties. The Landlord Self-Help Center has prepared its own version of additional lease clauses to include with the Standard Form of Lease. Our additional lease clauses can be found in the Members Lounge or are available for purchase for a nominal fee for non-members. Some examples of additional lease clauses include utilities, especially in circumstances where the tenant is required to pay a portion of the utility bill that remains in the landlord's name. The additional clause should outline exact percentage the tenant is responsible, how this amount will be paid, and when the amount will be due. Rules and exemptions, or rules and expectations, of common areas. For example, dogs must be on leash while using the common backyard. A clause allowing a landlord to take photographs in the rental unit for the purposes of not only reporting damage for legal proceedings, but marketing purposes as well, in the event that the landlord wants to sell the property. Yard maintenance and snow removal. There will forever be the debate regarding if snow removal and yard maintenance are the responsibility of the tenant or the landlord. Recent case law has been in favor of the landlord when the area was exclusively used by the tenant. If landlords are electing to have snow removal clauses or yard maintenance clauses, the areas tenants are to be made responsible for should not be any shared spaces and needs to be very clearly outlined in any lease amendment. Landlord Self-Help Center recommends seeking legal advice before attempting to enforce this type of clause. Another additional clause could be regarding parking. For example, determining the number of vehicles that are allowed in the space or banning the parking of commercial vehicles or unplated vehicles. A clause could also include that tenants need to ask permission to paint or that they must paint back to a neutral color at the end of the tenancy. Another good clause is to remind tenants that they are responsible to report any damage or issues in writing in a timely manner. A clause like this should be very specific. Something that may not be considered an issue to a tenant could result in a larger issue for a landlord. For example, a slow drink on a faucet may not appear to be an issue to a tenant or something that could cause damage, but could result in a large water bill for the landlord. Of course, this is not an exhaustive list. Landlords are encouraged to seek legal advice regarding additional clauses added to their lease agreements. Unenforceable lease clauses. Section 3, subsection 1 of the Residential Tenancies Act states, except Part V1, which is rules about nonprofit housing, applies with respect to rental units in residential complexes despite any act and any agreement or waiver to the contrary. Essentially, this means that regardless if the landlord and tenant agree to something, if it contradicts the Residential Tenancies Act, it cannot be enforced, meaning any action a landlord attempts to take against their tenant will not be successful at the landlord-tenant board. Common unenforceable lease clauses include no pets. Under Section 14 of the RTA, it explicitly states a provision in a tenancy agreement prohibiting the presence of animals in or about the residential complex is void. As such, regardless if the lease agreement says a tenant cannot have a pet unless the landlord can prove that the pets are causing damage or interfering with others, an eviction will not be granted just because of the tenant having a pet. No guests, roommates, or subletting. This is one that landlords often get really upset about. Regardless of who is a party to the lease agreement or any provisions restricting additional occupants, tenants are allowed to have guests. They're allowed to bring people into the unit to reside with them permanently up until the point of overcrowding. There are also rules around subletting, but it's a much more complex topic, and landlords should be seeking advice regarding their tenants' right to sublet. Late fees and other deposits are also unenforceable. Although charging a fee for late rent or damage deposit seems completely reasonable, the RTA prohibits against them. As such, landlords should not be including any prohibited charges to their lease agreements. Landlords should also be cautious that by doing so, their tenant may file an application with the Landlord-Tenant Board, or they could even be fined. The last example is tenant to pay for repairs. This is a common one I get asked about by landlords, especially who have had realtors draft their lease agreements. I've seen some that suggest that the landlord provide the tenant with a working appliance, and if it breaks, the tenant has to fix it. Others that claim the tenant is responsible for the first $100 of every repair bill. These type of clauses are not lawful. If a landlord is concerned about repair costs or the repair obligations, they should be seeking legal advice.
Inspection report. The Landlord Self-Help Center has an inspection report available on the members' lounge of our website. An inspection report should include all of the rooms and areas of a rental unit and set out the conditions upon move in and the conditions upon move out. The report should be filled out at the beginning of a tenancy and at the end of the tenancy. This will provide evidence of the state of the rental unit before and after. It is advisable to keep this report for your records. The inspection report should also be dated and signed by both the landlord and the tenants. Before/after pictures. It is best practice to take and save dated pictures before the tenant moves in to reflect the state of the rental unit. A landlord should take detailed pictures in all of the rooms within the rental unit. Upon move out, a landlord should take further dated pictures that show the state of the rental unit when the tenant has moved out. This helps with damage claims for negligent or willful damage before the landlord and tenant board. Landlord obligations. Sections 20 to 32 of the Residential Tenancies Act set out landlord obligations. Section 20 of the Residential Tenancies Act, sets out a landlord's responsibility to repair. A landlord is responsible for providing and maintaining a residential complex, including the rental units in it, in a good state of repair and fit for habitation, and for complying with health, safety, housing, and maintenance standards. This applies even if the tenant was aware of a state of non-repair or a contravention of a standard before entering into the tenancy agreement. Landlord obligations, vital service. Section 21 of the Residential Tenancies Act states, a landlord shall not at any time during a tenant's occupancy of a rental unit and before the day on which an order evicting the tenant is executed, withhold the reasonable supply of any vital service, care service, or food that it is the landlord's obligation to supply under the tenancy agreement, or deliberately interfere with the reasonable supply of any vital service, care service, or food. Subsection 2 states, if a landlord is deemed to withhold the reasonable supply of a vital service, if the landlord is obligated to pay another person for the vital service, landlord fails to pay the required amount, and as a result of the non-payment, the other person withholds the reasonable supply of the vital service. A vital service would be defined as electricity or hot water. Landlord obligations, reasonable enjoyment. Section 22 of the RTA states, a landlord shall not, at any time during a tenant's occupancy of a rental unit and before the day on which an order evicting the tenant is executed, substantially interfere with the reasonable enjoyment of the rental unit or the residential complex in which it is located for all usual purposes by a tenant or members of his or her household. Section 23 states, a landlord shall not harass, obstruct, coerce, threaten, or interfere with a tenant. Landlord obligations, changing locks. Section 24 states, a landlord shall not alter the locking system on a door giving entry to a rental unit or residential complex, or cause the locking system to be altered during the tenant's occupancy of the rental unit without giving the tenant replacement keys. Section 25 speaks to privacy. A landlord may enter a rental unit only in accordance with sections 26 or 27, which we will go over in a moment. For more information and tips on privacy for the rental housing sector, you can visit the website listed on the PowerPoint on your screen. Landlord obligations, entry. Entry without notice, emergency consent. Section 26 states, a landlord may enter a rental unit at any time without written notice in cases of emergency, or if the tenant consents to the entry at the time of entry. Section 27 of the Residential Tenancies Act speaks to entry with notice. A landlord may enter a rental unit in accordance with written notice given to the tenant at least 24 hours before the time of entry under the following circumstances: to carry out a repair or placement work, to allow potential mortgagee or insurer to view the rental unit, to allow a person who holds a certificate of authorization under the Professional Engineers Act or a certificate of practice under the Architects Act, or another qualified person to make a physical inspection to satisfy a requirement imposed under the Condominium Act of 1998. To carry out an inspection of the rental unit if the inspection is for the purpose of determining whether or not the rental unit is in a good state of repair and fit for habitation. It is reasonable to carry out the inspection, and for any other reasonable reason for entry specified in the tenancy agreement. A landlord may also have a broker or salesperson registered under the Trust in Real Estate Services Act enter a rental unit with written notice at least 24 hours before to allow a potential purchaser to view the rental unit. The notice itself should specify the reason for entry, the day of entry, and a time of entry between the hours of 8 a.m. and 8 p.m. The Landlord Self-Help Center also has a template for notice of entry available on our members lounge. And again, our website is landlordselfhelp.com. Human rights in housing. The Ontario Human Rights Code also impacts landlord and tenant relationships as it establishes the following. Every person has the right to equal treatment with respect to the occupancy of accommodation without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, age, marital status, family status, disability, or the receipt of public assistance. For more information, you can visit our website, landlordselfhelp.com/human rights and rental housing. Human rights and housing accommodations. Accommodation efforts are key. Accommodation requests need to be honored up to the point of undue hardship. A landlord needs to show that they have tried to accommodate the need of the individual. The tribunal will not consider a requirement reasonable and bona fide in the circumstances unless the needs of the group of which a person is a member cannot be accommodated without undue hardship, considering the cost, outside sources of funding, and health and safety requirements. That's Section 11.2 of the Human Rights Code. Undue hardship. Sections 11 and 17 of the code operate to create an obligation to accommodate a tenant with a disability or who is a member of a code-protected group. The code mandates accommodation with dignity and tenant involvement. It should have individualized solutions, not one size fits all. It should be with the full integration and participation of both parties, and it needs to be up to the point of undue hardship. Undue hardship means the costs must be so substantial that they would alter the essential nature of the enterprise or so significant they would substantially affect its viability. The landlord must consider outside sources of funding, government grants, phasing in the changes using funds from other parts of the organization, and more. A landlord must also consider health and safety risks to staff, if any, as well. Landlords may have to hire qualified experts and consultations. Speculation is not persuasive evidence of undue hardship. You must provide evidence such as financial statements, expert reports, etc.
Okay, thank you, Ashley. That wraps up the presentation part of this Lunch and Learn. Just as a reminder, the Landlord Self-Help Center has developed a number of resources that can provide more information to landlords, especially with the topic of beginning a tenancy. You can find those all on our website, which is landlordselfhelp.com. Some examples is the RTA fact sheet of the residential tenancies agreement and rent rules, our sound advice podcast and landlord learning modules about lawful rent, and past landlord learning videos. We also have our Facebook page, YouTube, and Instagram. Also, as a reminder, or to let people know, we'll be returning in the fall. So mark your calendars on October 22nd at 1 p.m. We'll be having the final Lunch and Learn of the year. It's about understanding the N5, which is a notice to end tenancy for interfering with others, damages, or overcrowding. I will now pass it over to our Executive Director, Diana, to facilitate the question and answer period.
Thank you so much, Catherine and Ashley. As everyone can see, this presentation caused a lot of uh, questions, so we're just going to go through all of them. So we'll start with the first one. Where does a guarantor go if not on the Ontario lease agreement? Catherine, would you like to answer that question, please?
Yeah, so you're not going to put the guarantor on the lease agreement because they're not a tenant. Only tenants go on the lease agreement. So you'll have to draft a separate contract with the guarantor. We actually have one prepared that's under our members lounge or available for a nominal fee. But essentially the guarantor is not on the lease at all. It's going to be a separate contract explaining that they are guaranteeing the rent essentially.
Thank you. Where do the details go as the lease is standardized? Is this a separate attached page? Uh, Ashley, would you like to answer that?
Yeah. So the standard form of lease has specific boxes for specific details. If you're looking to add additional terms, then yes, you can attach pages to it. There's a box on the standard form of lease that asks if you have additional terms, and you would select yes and then attach those to it.
Thank you. Can the address for the landlord be a representative's address? Does it have to be their home address? Can it be a PO box? Catherine, would you like to answer that?
Yeah. So by representative, I'm guessing you maybe mean like property manager, which a lot of landlords do. PO boxes, I would say away from unless you have constant access to it. Um, if you have a specific question about, your address or the address that you're using, you can call us later in the week and we'll talk about your specific issue.
Thank you, Catherine. Ontario laws are in favor of tenants, resulting in tenants refusing to vacate the property and or refusing to pay rent. The LTV process is very long and favors tenants. What should landlords do when tenants refuse to leave the property? Ashley, would you like to answer that?
Yeah, so a landlord would need to follow the proper processes as set out under the Residential Tenancies Act. So in the case of non-payment of rent, for example, they would serve an N4, which is a notice to end the tenancy for non-payment of rent. They would file an L1 application if the tenant doesn't void the N4, and they would proceed to a hearing. So you do have to follow that process and wait for that order in order to properly evict.
Okay, somebody else is asking, how should rent increases be communicated for rental units not regulated by rent controls? Catherine, would you like to answer this?
The Landlord Tenant Board has actually created a prescribed form for exempt, like rent control exempted units. It's called the N2. So the same as units that do fall under the guideline, you still have to give 90 days notice and the increase can only take place every 12 months. So instead of using the typical standard N1, you're going to be wanting to use the N2.
Thank you. If parking is listed separately, can you increase the parking rate yearly to any percentage? Ashley, can you answer that, please?
So it's really going to depend on the specific circumstances that you have in your specific lease. So I would definitely recommend giving us a call and letting us know the circumstances and how it's listed, because it's one of those answers that it really depends, potentially, but it really depends. So I would definitely give a call and get some more specific advice for your situation.
Thank you. Is it true that landlords cannot ask for post-dated checks anymore? Does this mean you have to go and collect a check each month? Catherine, can you answer that, please?
Yeah, so it can't be a requirement. So essentially, you can't say to the tenant that they have to provide you with post-dated checks. If the tenant agrees to or is okay to provide post-dated checks, then the landlord is still allowed to collect, multiple checks, but it cannot be a requirement. So if the tenant only wants to give you a check every month, then as the landlord, you're just going to have to accept the check every month.
Thank you. For utilities like water and heat, which changes monthly. How should that be included in the rent section for a duplex? Can that be charged based on true use for the duplex, or will it be charged as a flat rate monthly? Ashley, can you answer that, please?
Yeah, so under the section of the standard form lease, which is section 6, which is services and utilities, you would select who's responsible for the payment of those utilities. So if it's going to be the tenant, then you would select tenant, and then you would list the specifics of what, like the portion that they're going to pay. So if they're responsible for their full bill, you would make sure that that's clear. If you have a more specific question based on your circumstance, again, if you want to give us a call, I'd be happy to clarify that further as well.
Thank you. The next question says, if you're providing services like paid laundry and the machine breaks, do you have to have a replace or repair within a certain time period? Catherine, would you like to answer that?
Yeah, as a landlord, you do have the obligation to keep everything in a good state of repair that is provided within the lease. There isn't a specific time frame. Like the Residential Tenancies Act doesn't say if something breaks, it needs to be replaced within 24 or 48 hours. Obviously, I would recommend acting, diligently and trying to get it fixed as fast as possible. If you have more concerns, then feel free to call the office.
Thank you. So rental increase. Are landlords entitled to increase the rent as per CPI, even though the rent has decreased, or same from original rental when contract was signed? Ashley, would you like to answer that?
So I think I'm going to need more details on the specifics of the question itself. Generally, the rent increase is based on the current lawful rent. So if they're paying, let's say, 1,050, you would do the 2.5% based on the 1,050 that you're charging. But that question may have more nuances. So if you want to give us a call again, I'd be happy to discuss further.
Thank you. The next one is, why is a separate written agreement or a written document for post-dated checks necessary if their use is already specified in the executed lease agreement? Catherine, would you like to answer that, please?
Yeah. So the requirement of post-dated checks should not be in a lease agreement because it's not actually lawful to make a requirement. So yeah, I would take that out of your lease agreement. If the tenant is electing or choosing to willfully pay by post-dated checks, there should be some sort of record that the tenant has made that choice, that it's their choice to do it, not that it's out of necessity or a requirement from the landlord.
Thank you. The next one is, if the unit is furnished, are you allowed to take a furniture deposit in a separate agreement? Ashley, can you answer that?
So no, you wouldn't be able to take a furniture deposit. The only deposits prescribed under the Residential Tenancies Act is the last month's rent and then the key deposit.
Yeah, and we don't advise landlords to do that because once again, whatever you provide, you're still responsible to maintain. So it includes appliances or even furniture. So it just complicates matters more. How can a key deposit be only $30 when it costs over 100 for a garage remote fob? Catherine, can you answer that, please?
Yeah. The $30 was just the example Ashley gave. You're allowed to collect a key deposit for the same amount that it would cost to replace the keys. So I know like condo fob specifically can be like 100, sometimes $100, like $150. If that's the case, then your key deposit can reflect that. It could be 100 or $150. 30 is not the cap. It was just the example that we used.
Thank you. The cost includes both the key and the key cylinder, correct? Simply cutting a new key without replacing the cylinder can be risky. So this is kind of related to the previous question. So once again, Catherine, can you repeat the answer?
Yeah. So the key deposit is simply for replacing the key, not cost incurred by the landlord for changing the locks. So if it's just your standard old key that you can, go to Home Hardware and get cut for $15, that's the most that you can charge. You can't charge for, the $200 cost that may cost for a locksmith to change
Thank,
the whole contraption.
Thank you. So for smoking, if the tenants smoke indoors in a duplex and that is listed in the details as something not allowed to happen indoors, how does a landlord remedy a smoking tenant? What happens if the smoke creates a lot of damages? This is definitely something that will be addressed in our next webinar pertaining to the N5 notice. But yeah, this is not related to the presentation. We invite this person to call our office and discuss more about what they can do. So the next one is, how is overcrowding defined in the context of a 3-bedroom townhouse? Ashley, can you answer that?
Yeah, so overcrowding is definitely going to be defined by your local municipality bylaws. It's usually based on the square footage. So you would need to know the square footage of the property and then how many people are living there to determine if it's overcrowding or not.
Thank you. So regarding tenant insurance, I can't remember if this is a law that they have to get it and show proof. Can you address this, Catherine?
Yeah, yes. So under the RTA, tenant can be required per the lease to provide not only have insurance, but provide proof of insurance. So if your tenant is not doing that, that's something that you could put on an N5. And again, we'll be discussing that more in our next webinar.
Yeah, so today was more about showing you what kind of clauses you can include in your lease agreement, but in terms of enforcing those clauses, this will be more of a topic to be discussed in our next webinar. So if the tenant keeping extra guests like parents in their rental unit for a long period of time and utilities are included in the rent, can the landlord ask the tenant to pay more rent to be paid for the guests? Catherine, Ashley, can you answer that, please?
Yeah. So a landlord wouldn't be able to ask the tenant to pay more rent or utilities. So even if they have a guest or occupant come live or stay with them, what's in their lease maintains the same. So whether if you're paying for the utilities and they have someone come live or stay with them, you wouldn't be able to ask them to pay more for that.
Thank you. So somebody is asking, what if the tenant refuses to let the landlord into the unit, even with a written notice? So yeah, this is definitely something that will be addressed in our next webinar. But yeah, you can call our office to discuss this question. Can a tenant deny entry for inspection if landlord follows all the guidelines? Catherine, can you answer that? Can they deny?
I mean, are they lawfully allowed to? No. Does it happen? Yes. Again, this is a common problem. You can call our office to discuss, but it's an N5 situation, which we'll be talking about in the next webinar.
Is the fire inspection by a fire inspector a reason for entry with 24-hour written notice? Ashley, can you answer that?
Yeah, so Section 27 of the Residential Tenancies Act doesn't specifically list like a fire inspection with a fire inspector. You can definitely include that in your additional terms in the lease. If the inspection is to determine whether the unit is fit for habitation, which I think in a fire inspection it probably would be part of that, then you could file it under the inspection to check for fit for habitation and that all the maintenance and standards are being met.
Thank you. If one of the tenants on the standard lease wants to leave and has a new tenant that will take over their portion of a lease, can the landlord redo or amend the lease to include the new tenant? Catherine, can you answer that, please?
Yeah, that's arguably, I mean, you could consider that an assignment. We have an assignment template in the members lounge of our website. So you could do it by doing a separate document to note the changes, or you could completely redo the whole entire standard form of lease. However, the terms of the lease would have to remain the same, provided that there's still a existing tenant staying.
Sorry, so I think that question would need a little bit more details because we're not sure if we're talking about a lease for the entire property or separate leases. So if it's one lease for the entire property and has multiple people and they're just swapping one person for another, that's a different situation. It wouldn't be necessarily an assignment, but I think we need more details about that question. So yeah, that person can definitely call our office to give us more details about it. Somebody is asking, to clarify, does human rights accommodation mean that in a residence with stairs, the tenant has the right to get the landlord to pay at landlord's cost, putting in a ramp? Ashley, can you answer that question, please?
Yes. So the duty to accommodate is up to the point of undue hardship, like I said before. So, I mean, call in for specific legal advice if you have this specific situation, because it can vary depending on the situation. But the general answer there would be yes, the landlord would be responsible for accommodating that.
Thank you. Um, so when landlord is receiving documents with a rental application by email, how can the landlord ensure the tenant's information is secure? Can you answer that question, Catherine? A little bit more of a technical question.
Yeah, I'm not quite sure exactly what you're asking. Like, how do you verify that the information is correct? Or um, maybe I see that it was Irene who answered that question. Give our office a call. We can talk about it specifically to your situation. I'm sorry, I'm not quite sure what you're asking.
Thank you. Somebody's asking if the landlord can request a criminal record from the tenant. Ashley, can you answer that?
There's nothing specifically prohibiting it in terms of requesting. However, it's not something I would recommend because you can't use that information to deny someone on the basis of that record. It would fall under potentially the Human Rights Code. So, if there's a specific situation, again, definitely give our office a call and I'd be happy to discuss that part further with you as well.
Thank you so much. Um, okay, let's see. We're still getting a lot of questions. We're just going to go over some for like 5 more minutes. Um, let's see. Uh, okay, so a question about joint leases. If I sign a joint lease with multiple tenants and one tenant abruptly leaves before the end of the lease term, am I able to pursue the tenant that left for the remaining months, or do I collect that now from the remaining tenants? Catherine, can you answer that, please?
Yeah, so one tenant can't unilaterally get out of the lease. Everybody on the joint lease would have to agree to it. Um, so if the people who are staying in the unit agree to take over, that would be the most simplest way. Otherwise, while the fixed term is still taking place, the tenant who just decides to up and leave would still be liable for any unpaid rent, along with the tenants who are still currently there.
Thank you. Um, let's see. Is having a co-signer or guarantor upon the landlord's discretion? Ashley, can you answer that, please?
Yes, it is. However, the Human Rights Code itself is very clear that if you're going to require a guarantor from one person, then it should be across the board. For example, you can't only require a guarantor for someone who's on ODSP. If you're going to do it, you need to do it for all of your applicants and tenants. It can't be singled out for a specific reason. But it is landlord's discretion, yes.
Thank you. Um, so let's see. For any questions that pertain to your specific situation, yeah, we definitely invite you to call us. A lot of the times, in order for the paralegals, community legal workers in the office to give you an accurate answer, they need more questions. So, yeah, it's not enough just how the questions are formulated. There's more information needed. Um, let's see. Mm, what other ones? Okay, somebody's asking about the day that the non-rent control buildings go into effect. If a newer condo, is it the occupancy date or final closing date if both were in 2018? Yeah, we would need you to call us, please. This is not necessarily related to this presentation. Um, Somebody saying we are going to purchase a building with rental units with current tenants. These rents are very low, and we're going to need to increase the rent. As a new landlords, can they increase the rent to what they need them to be, or is there a limit? Catherine, can you answer that?
No, you're going to be subject to the guideline, the 2.5 every 12 months. If the rents aren't going to maintain the mortgage, then maybe it's something that shouldn't be purchased. Just because it's a new purchase and you're taking over tenants, you can increase the rent.
Thank you so much. So yeah, unfortunately, based on our time constraints, we're not able to go through all the questions, but feel free to email your questions, include your phone number. We can call you or just call our office during our business hours, and we can definitely discuss your questions. Thank you everyone for watching our webinar, and um, and thank you for Catherine and Ashley for presenting as well. We would appreciate your feedback about this webinar. So if you could please fill out our survey, you can see the QR code on the screen or visit the website. So thank you so much for attending. You'll also get an email post webinar with the link to the survey in case that you don't have an opportunity to get the to scan the QR code right now. But thank you everyone for attending.